Dear participants, a very warm welcome to this webinar. I'm Professor Pascal Pichonnat from the University of Fribourg in Switzerland, and as President of the European Law Institute, it is my great pleasure and privilege to welcome you all to this webinar. In February 24, ELI membership has approved the so-called ELI Charter of Fundamental Constitutional Principles of a European Democracy, a fantastic project and endeavor to set out the fundamental constitutional principles of a European democracy. We at ELI think that this project is timely and will become of great importance as a kind of milestone, given also the current and ever-changing political situation in Europe and around. Given the importance of such work, the ELI decided to organize a series of webinars to discuss the various parts of such ELI charter. As the project consists of 7 parts, we decided to organize 7 webinars on each single part. Today, we will tackle the principles presented under the heading 1, Liberal Democracy. The charter contains, however, further chapters: the rule of law, judicial independence, checks and balances, accountability, dignity and equality, protection of fundamental rights, and a 7-chapter constitutional integrity. As we have done with other projects, each chapter is broken into principles, and each principles accompanied with a succinct commentary on its intended meaning and scope. The reporters have also provided an indicative list of references to legal sources. Now, the 2 reporters, Professor Elise Muir and Professor Takis Tridimas, have achieved an incredible work under the chairmanship of Sir Francis Jacob and first president of the ELI, and Sir Geoffrey Drowell. Now, this project has been presented and discussed several times, of course, with the scientific director of the ELI, Professor Christiane Wenderos, and the executive committee, as well as the ELI Council, and finally has been adopted by the ELI membership, but it has been also discussed at several high-level conferences on constitutional law. The final outcome is therefore the result of the individual work of the co-reporters, but who benefited also a lot from collective thinking and interactions. I have to underline the readiness of the reporters to review their work over and over to try to reflect ideas that would be important for the quality of the overall result. There will be further bi-weekly webinars to discuss other parts, and therefore we will make and continue to make a lot of publicity around these principles. But before giving the floor to our outstanding set of panelists, let me say how pleased I am to be able to tell you that there was a lot of enthusiasm by all the panelists we contacted to get on this panel and to participate to the whole series of webinars. So do not miss to attend the next webinars as well, because they will also be very exciting. As always, you will be able to ask your questions thanks to the Q&A function, and we will answer those questions in the end after the first round of presentation. But let's start now with one of the 2 co-reporters, Professor Dr. Takis Tridimas. He is the chair of European Law at Dickinson School of Law, King's College London, and director of the Center of European Law. He is also professor at Pennsylvania State University and a barrister in Matrix Chambers. He is the author of numerous publications, including a book on Oxford Principles of European Union Law, Volume 1, the European Union Legal Order. This is just to say that we have here a wonderful reporter and expert, and I'm really happy, Takis, to hand over to you.
Thank you very much. Let me first say that this is a great honor. I am extremely grateful first to my co-reporter, Professor Elise Muir, all the members of the drafting group and the advisory committee. It would simply not have been possible to see this project to fruition without their unfailing support. Secondly, Also, I'm extremely grateful to the Institute, to the president of the Institute, to the scientific director, again, for their patience and their unfailing support. It was really they that conceived the project and enabled this to be carried through. So I have it's a great honor for me to have led this, and have done this with trepidation owing to the importance of the subject. So what I was going to do now is simply present the project, what we are, what are the objectives, what we are aiming to do, and secondly, say a few words also about the first part, which is the subject matter of today's seminar. So this is a charter on fundamental constitutional principles, and what we have sought to do is to encapsulate contemporary European constitutionalism, the DNA, if you wish, the sine qua non elements of a European liberal democracy, its core values. And by the term liberal democracy is non-partisan. This is extremely important to emphasize. It is based on the common constitutional traditions of European states after the Second World War. And essentially, it means that a state should be governed by the majoritarian rule, but subject to the protection of fundamental rights and recognizing to the citizen a sphere of personal autonomy. So the overarching themes of this are, I would say, the following: democracy, rule of law, and fundamental rights. We are not drafting a constitution, a model constitution. What we are trying to do is bring together a set of standards, rights, principles, and state obligations, if you wish, that make up the fundamental underpinnings of a well governed constitutional democracy. And I think no document of this type so far, to the best of my knowledge, combines principles of governance and principles of fundamental rights. We are trying to marry the past with the future. And I think there are a number of reasons why this document is timely. I think it is correct to say that liberal democracy is at risk. It is seriously questioned, both from outside and from within, if you wish. Looking at a number of independent reports, the VDEM Institute report, the Freedom House report, our World in Data report, they record a regression on democratic standards. Now, these reports use different methodologies. One may disagree with a particular classification of one country, but I think cumulatively taken together, they suggest that vigilance is required. So the report, we think, comes at a timely fashion. It includes principles which are not necessarily included in national constitutions. For example, we have included principles there about the need to prevent corruption, about automated decision making, or the need to prevent and combat disinformation. And I think given European history, the importance of restating those values cannot be overstated. Regression is possible where it comes to the protection of rights, and vigilance is required. I think also we need to remember that it is still, even though since the Second World War we have benefited enormously in Europe from good governance standards and an increase in the protection of the citizen, it is still very difficult for citizens to assert their rights, to take on the state. Sometimes, especially academics, we are too preoccupied with the case law of Supreme Courts and their power of judicial review. But democracy is a lot more than that. It requires, first and foremost, preventative standards before we get into a remedies for violations that have already taken place. Also, the discussion is not only pertinent to public law. I think it is also pertinent to private law, because the assertion of private rights against other private parties requires a well-functioning system, a well-functioning democracy, judicial independence, and so on and so forth. So we are seeking to address also contemporary challenges. There are principles there on the digital environment, disinformation, the regulation of artificial intelligence and automated decision making, although we of course recognize that this is an extremely fast moving area, and one needs to be minimalist, because we need to see how things develop before one would be able to articulate more precise fundamental principles. So there is a set of principles of governance and a set of rights. There are 36 principles in total, and these are divided into 7 categories. Liberal democracy, which we are discussing today, the rule of law, judicial independence, accountability, the idea of checks and balances and separation of powers, dignity and equality, protection of fundamental rights, and so-called constitutional integrity. These are the 7 parts that make up the report. Let me say very quickly a couple of things about today's part. This is the first part on liberal democracy. And essentially, very briefly, the principles that we include there are the following. The first is the underlying values, the founding values, which are contained in Principle 1. And these essentially are respect for human dignity, respect for democracy, the rule of law, equality, and fundamental rights. The message here being that democracy is not only a governance system, it is a form of society. It is a set of rules that essentially provide for a political space within which citizens can enjoy freedom and can decide collectively certain things. The second principle, representative democracy, provides the starting point, the majoritarian rule. The idea is that sovereignty is vested on the people. This is recognized by many national constitutions. They exercise it through their elected representatives and through different branches of government. The second principle states that the primary legislative function is exercised by Parliament. We don't mean by that there is a preference towards parliamentary democracy as opposed to presidential democracy. I think the core issue is that policy decisions must be taken indirectly by the people. There is a set of other principles under Principle 2. One principle which caused difficulty, and it was debated very thoroughly, was the principle contained in the 3rd paragraph of Principle 2, which states that members of Parliament represent the electorate as a whole and are not subject to a bound mandate. There is a tension here between political reality, if you wish, the way political parties work, the need for party discipline on the one hand, and the idea that the political representatives of the people act according to their conscience. They are not hostages, if you wish, to specific preferences of their electorates. Principle 3, elections. We have there borrowed heavily from the case law of the European Court of Human Rights, which has articulated a number of standards that should govern elections. We have also borrowed from the Venice Commission that has articulated standards. The idea is that elections must be free, fair, and regular. They must be secret, they must be universal. And this is an area where the state does have a number of positive obligations. We have identified the need for inclusiveness in defining the electoral body. We have discussed about certain groups which pose rise to challenges. One of these groups is prisoners, whether prisoners should have the right to vote. This has created controversy in recent years. The other group is non-residents. And of course, it goes without saying that there is a large margin of appreciation for the individual states in drawing the boundaries of the electorate. The Principle 4 talks about political parties and the importance of political parties, the pivotal function that they have in a liberal democracy, and the need to ensure that citizens are free to form parties, but also, if I can highlight just one element from this principle, the need for political parties themselves to abide by the underlying values of democracy. Every democratic society should have the right and the power to defend itself, and political parties themselves must adhere to these underlying principles. Principle 5 talks about freedom of the media. This is although it comes from the right, from the freedom of expression, it is absolutely pivotal to the well-functioning of the democratic system. And finally, Principle 6 talks about the protection against disinformation. This is a contemporary challenge which is exacerbated by technological progress. There are difficulties in defining the term. There are difficulties in ensuring who are the gate keepers. But the fundamental point is that the democracy is predicated in the active participation of an informed electorate. Because only if the electorate is well informed, it can express its fair and free choice in the electoral process. So the need for accurate and trustworthy information is absolutely key. Of course, there are competing rights, the freedom of expression on the one hand, the need to combat disinformation on the other hand, but different states may draw the balance between them differently, but we believe that there is a minimum set of principles, a minimum set of obligations on the state or to combat disinformation. And this is an obligation which is not addressed only to the state. Intermediaries like online platforms, public and private media undertakings have a particularly important role to play here, because essentially, by the nature of things, they take the form of gatekeepers. So this is a bird's eye view of the project, the objectives of the project, and also a bird's eye view of the 6 principles contained in the first part on liberal democracy. I would, of course, be very happy to answer any questions that may arise. Thank you very much.
Thank you very much, Takis, for, as you said, this overview, which is really interesting and fascinating. And we indeed look forward to any questions that will be posed by the participants. But in the meantime, let's go to our second panelist, and that's Ralph Kessner, Head of Unit at Justice and Home Affairs at the Council of the European Union. He studied in Germany, in Switzerland, and then in the US. And he practiced EU competition law with an international law firm in Brussels before joining the General Secretariat of the Council in 1999 as a legal advisor. And then I wanted to say he grew up, went up the ladder, worked also at some point for the EU High Representative for Common Foreign and Security Policy, Javier Solana, to advise on a broad range of foreign policy topics. In 2009, he advised the EU on EU policy as a member of the private office of the Secretary General of the Council, Pierre de Boissieu, and later Uwe Gorsepius. And in 2014, he joined DG JUST as head of unit for fundamental rights and values and rule of law. So who better placed than Ralf Kessner to present some reflections on values and representative democracy, recent developments in the field, including from Council of the EU's perspective. You have the floor.
Yes, hello. Thank you very much, Pascal. And it's an honor to be here. It's a rainy day in Brussels, so I'm happy to be here and having some interesting discussions on these very fundamental things. Now, first, congratulations, of course, to the ELI, a very fantastic topic. The charter is very impressive. I think it will be a piece of reference in the future. I'm coming now here from the Council Secretariat, so our job is to accompany the member states in their discussions. I cannot speak on behalf of the Council, of course, only the presidency can. So I can only give you some personal views on how the whole developments have shaped up here in Brussels over the last years. And this is really a practitioner's point of view. I'm sorry if in academic terms, perhaps it's sometimes a little bit not so academic, what I would say, but it's Chatham House rules. I will just give you my personal take on how the field has developed over the last years. Now, well, first of all, it's a great topic. It hits the spot. Yeah, the Union is at the moment looking before the EP elections at the next enlargement already and how to protect the fundamental values of the Union in a 30+ European Union. Geopolitically, of course, Takis has already made reference that there is a kind of global attack on democracy to some extent. You can say that it is a frontal attack on liberal democracy. And so how does the European Union position itself on this topic? It's good to first take a look. Let's look at what has happened in the Union over the last 10 years, and it's because it's been quite impressive, I would say, how the development has how the assessment has changed. Yeah, we all know that Article 2 of the Union sets out the holy grail of what are the fundamental values of the Union. Yeah, it is democracy, it's rule of law, it's respect for fundamental rights. And but it's also clear that at the very beginning, it was more assumed that the member states took these values for granted almost. Everybody who joined the Union had to join NATO. After NATO, you became a member of the Union. So basically, I mean, it was pretty sound to assume that you are a liberal democracy. Okay. Over the last, or let's say, since perhaps 2007, the last big enlargement, I think there the assessment has now changed. And I think there's three things that stand out, really. I think the first thing is that member states now consider the kind of the holy triangle of democracy, rule of law, and fundamental rights as a non-negotiable part of the Union project. They are convinced that you cannot have a justice area where you recognize mutually judgments without being sure that the other person sitting next to you at the table respects roughly at least the same values. The internal market cannot function as it is conceived without it. And in foreign policy terms, you cannot be credible on the international stage. and versus candidate states that want to join, if you are not able to maintain these principles inside of your own club and your family. So that is the first thing. I think it has become a non-negotiable element of the union. I think that the second element is that the union has used the last 10 years to sharpen its defense mechanisms. Now they have put up some watchtowers, have set out some tanks, some artillery to kind of protect these values. You have the Article 7 procedures, you have the rule of law report that the Commission is preparing. You have a lot of discussions among ministers on the rule of law in the union. You have a conditionality regulation that can sanction a member state for rule of law breaches if the financial conditions of the budget are endangered. So a whole lot of instruments has been established to protect these fundamental values. And that is really new because 10 years ago, member states were not so convinced that the union should have a role in these things. It was considered to be national sovereignty, how to organize your country, your system. Once you were in, you were in. And that is clearly a different thing. So that member states accept now this role of the union in monitoring these fundamental values. And I think the third thing that really has changed over the last 10 years is what the Court of Justice in Luxembourg has done. They really have written constitutional law by a ruling that these fundamental values of the union, they are not ornaments. They are enforceable law. They are, when the treaty speaks about effective judicial protection, the court has said that this basically means your judiciary has to be independent. Now, in the ruling on the conditionality regulation, so whether you can impose financial sanctions basically and rule of law breaches, the court has said, well, these fundamental values, democracy, rule of law, and fundamental rights respect they define the very identity of the union as a common legal order. The compliance by member states with these values is a precondition for the enjoyment of all the rights of this member state under the treaties, and that therefore the union is perfectly entitled to protect these values and to defend them. And that is, I think, that has set somehow the frame new. So that has not been there 10 years ago, and it is now there. And it is really up to member states now how to, and to the Commission, of course, to the Parliament, how to use this framework that has now been established on these fundamental values. And if we look at these three things and at the current debate in the union on enlargement, on how to protect them in generally, there's a couple of things that can be said when looking ahead. One is there will be no rolling back of the involvement of the European Union in this area. It will rather be strengthened rather than be rolled back. And also there will be no differentiation between the member states. At the moment it's 27. Who knows? In 5 years' time there might be 32. And it's hard to imagine that there will be any sort of variable geometry, any sort of differentiation this year. Now the fundamental values, they apply equally to all members. There's a symmetry of rights and obligations there under the treaties, and not like Schengen, not like the euro. It's for everybody. Now, a second thing that can be concluded is also that the member states will be probably inclined to further tighten the defense mechanism, to further sharpen the tools. There's a couple of lines, avenues that are already being discussed. But it's clear that member states want to make sure that especially a new candidate country that accedes to the union, once it is in, basically thinks it's okay, now I'm in and I don't have to worry anymore. There should be, the idea is then to make sure that there is, well, you can have several avenues. Yeah, you can sharpen the budgetary tool even further. You can You can have a transitionary period for a new member state where the sanctions can be even harsher. You can target sanctions of pre-accession aid, financial aid, if in case a candidate country does not respect the commitments on these fundamental values. So I think there's still space for the Union to sharpen the toolbox, and at the moment the discussion is pretty freewheeling on how to do it, but it will probably come. It's very likely. There's also of course, the possibility of further sharpening the next MFF, the next financial perspective tool to make this far more contingent on member states giving plans, committing to fulfilling certain conditions before money can flow. So, but at the moment, it's clear that there are many options. However, what every member state at the moment is weary of is a treaty change. So basically, there will be a tendency to say, okay, let's see what we can do inside the treaties. We are not very keen on changing the treaties because that is a really heavy process. So I think then just to conclude almost already, it's to say that over the last 10 years, the Union has really made serious efforts to upgrade its toolbox to defend these fundamental values of democracy, rule of law, and the respect for fundamental rights. And a broad majority of member states accept these new powers of the Union in this area. Then it's no longer a national sovereignty area. It's now in the Union. And the prospect of the next enlargement will certainly convince many governments that more action is still needed. And ultimately, though, the discussion here in Brussels also shows that there's a certain dilemma, of course, a word of caution. Ultimately, this will not be a legal battle, and also the Court of Justice can only do so much. Ultimately, the real battle is political, and there you run into the wise man, as he said many years ago, that liberal democracy rests on conditions and on premises, the existence of which it cannot guarantee forever. So it is really a fragile thing. You have to trust that the overall mainstream of political thinking in Europe continues in that way, but you can never be sure. So I think that will be that is the word of caution at the very end. Thank you very much.
Thank you very much. Thank you very much, Ralph, for this overview and also for drawing what lies in front of the EU right now in light of these fundamental principles. We will continue our journey, if I may say so, with Daniel Popescu, head of the Promoting Local Democracy Department of the Congress of Local and Regional Authorities of the Council of Europe. I think that's the whole title. And he's been in charge of issues of democracy and governance in the Council of Europe since 1997, while he currently works for the Congress of Local and Regional Authorities. He focuses, of course, mostly on local and regional democracy, but his function until the end of 23 included issues of democratic standards, governance reforms, elections, and participatory democracy, and therefore we are exactly on the topic today. So I look forward to his reflections on the elections, participative forms of democracy, and so on. You have the floor, Daniel.
Thank you very much, Chair. And indeed, going from the Council of the European Union in rainy Brussels to the Council of Europe in sunny Strasbourg, where indeed we keep ourselves busy with the issues of democracy, human rights, and the rule of law, exactly what Mr. Tridimas explained at the beginning. Now, I confess that I accepted to join this panel not only because Tomasz insisted, but because it is indeed a very, very topic theme. And in fact, I'm not sure that you are aware, but the Council of Europe last year had only its fourth summit of heads of state and governments in its 75 years of existence. So we have a tendency to give some weight to the decisions taken on such occasions. And the heads of state and governments concluded with an agreement to adopt 10 principles for democracy. Now, mind you, they're not principles of democracy, but principles for democracy. So my understanding is that these are the areas where the countries, the 46 members, think they have still progress to be done. Now, I accepted to speak a bit about elections because until the end of last year, I was also dealing with the issue of helping governments and central electoral commissions to improve the way they organize elections. But then going through the document and also seeing that Mr. Spano is on the panel, I think there is very little for me to add. In fact, indeed, as Mr. Tridimas said, the Article 3 of Protocol 1 of the European Convention on Human Rights on the right to elections is very well referenced. And by the way, the European Court issues these thematic fiches, which are excellent, honestly, and for the one on elections, which presents the basically an abstract of the common law of the court in this respect, is an excellent read. I would recommend to anyone. Very good job there. And also the results of the work of our Venice Commission, which indeed has what they call a code of good practice on electoral matters. To me, this is a European standard of electoral principles of electoral heritage, and indeed there are 6 principles, of which Mr. Tridimas actually mentioned 5, and I think one is conspicuously absent in the document, if I may say so, the one of direct suffrage. Because if you wish, China also has elections, but only at local level, and sometimes sub-local level. All the others are indirect until the very top of the state. So I think the issue of direct elections is still has its importance in European electoral heritage, at least according to the Venice Commission. Now, what else I could say about elections is more looking a bit at the trends. We have a bit of a very small, very modest database where we register the results of elections to try to build some trends and some statistics and some diagrams. We like diagrams, of course. There we can see a number of things. The most striking one is that the turnout of election has been following a downward trend in the last maybe 30, 40 years, basically. So there are, spikes and changes, but then there is mainly a reversion to the mean, which is decreasing. And that's very worrisome, because if this trend continues in maybe 3 or 4 years, on average, in the larger Europe of 46, we would see that on average, less than 50% of those who are entitled to vote actually do so, which indeed raises question about what Mr. Tridimas said, that people should decide collectively. This is a worrisome trend, which is added to the other, of course, statistics that we have, the trust in government and its various institutions, which is also at historic lows. The questions about optimism, about the direction in which the country is going, and so on and so forth. All these indicators are in red, so that's why our Secretary General referred several times to the backsliding of democracy. So I think that's an important trend we need to be monitored, and not only monitored. Monitoring is easy, dealt with. And then I can maybe say a few words about how to do so, but I see that I only have a few more minutes left. The other one would be the question of electronic voting. Electronic voting, we saw there was a lot of fear in, let's say, 10 years ago, 8 years ago, 5 years ago. We meet regularly with representatives of central electoral commissions and of governments. And all of a sudden, in the last 4 or 5 years, we see a renewed interest. More and more countries are looking into the possibility to introduce electronic voting, regardless of what this means, voting on electronic machines in the polling stations or remote voting. And indeed, there are many questions about it. I personally believe that technology is a bit like water. It will infiltrate, so it's better to channel it rather than just try to stop it. So that's why the Council of Europe has the only international standard in the field, which also happens to be actually quite good. It's a recommendation from 2017. Which also comes with an exploratory report and especially with the guidelines for implementation. And this package taken together, I think it's an excellent piece of work and a standard which can be very useful. But going beyond that, beyond the one Mr. Tridima said, rules, a set of rules for creating a space where citizens can have freedom and decide collectively. Do they decide collectively? The Secretary General of our organization also noted a disconnection, a growing decorrelation between what citizens expect and what policies are taken. I will only refer to one example, which is taken from, not from Europe, but from the US, because they have many such studies. The study of 2014, Chilens and Page, from two major Ivy League universities, which found a correlation between how strongly citizens support a decision and how likely the decision is to be taken of 0.0%. So we are in a situation where more, let's say, influence of citizens needs to be injected into the decision-making process. And this does not necessarily concern constitutional rules. This does not even necessarily concern legislative obligation. It's just, this concerns a practice of having more of these, citizens, consultations, assemblies, and so on. And to make a story short, because I only have 1 minute left, the Council of Europe adopted last year the first, for the moment, international legal standard on deliberative democracy, a recommendation indeed, 2023-6, which establishes some do's and don'ts about this kind of processes, which can be very useful, but also very grossly misused. Now, I would honestly love to engage into a discussion especially with Mr. Tridimas, about the definition of democracy. I once met with a big panel of NGOs from all over Europe and proposed to them 7 different definitions, and each of them had about 15–20% of the respondents adhering to them, and these were very competing definitions. So I believe that indeed we are looking now at a set of rules, constitutional rules, and we in the Council of Europe also will be looking probably into the question of parameters of democracy. But the issue of democracy exceeds the question of rules. It's also a question of practice. It's a question of culture, of mentality. It's a question in the end of allowing citizens to have agency, meaning the capacity to form an opinion and act of it, and influence, to influence the decisions which are taken on their behalf. I will finish here. I'll exhaust my 10 minutes. Thank you very much.
Thank you very much. Thank you very much also for this perspective from the Council of Europe and the whole expertise, including on these elections issue, which are indeed fascinating, and to give a voice to the people in a meaningful way is central. So we might come back to that. We'll continue now with Dominika Biczawska-Siniarska. She's a senior advisor at Central Europe program of the Prague Civil Society Center. And she's an experienced human rights lawyer. She's previously worked at the European Court of Human Rights and has been the director of the Media Freedom Observatory at the Helsinki Foundation for Human Rights since 2008. And she had also served on the advisory panel of the European Union Agency for Fundamental Rights and was a member of the Helsinki Foundation for Human Rights. management board for 5 years. For her contribution to freedom of speech, Dominika got an award of Article 54 of the Polish Constitution, and now she will, of course, address these issues of freedom of media, which is encapsulated in Principle 5 of the ELI Charter. So, Dominika, I give you the floor.
Good afternoon, everybody, from very gray and rainy Warsaw. It's a pleasure to be here, and thank you very much for the invitation. I would basically like to focus on two issues. So first of all, coming from a state which had turbulences as far as democracy is concerned, and I'm thinking here of Poland, I would like to highlight some of the main problems we had with media freedom and freedom of expression, and then refer to the Charter and to how these problems could have a remedy. So I think we are here in such an excellent group that I don't need to repeat why freedom of expression and freedom of media is so important for democracy, and this is the cornerstone for democracy, which has been highlighted in numerous judgments of the European Court of Human Rights, in numerous opinions of the Venice Commission or recommendation of the Council of Ministers, obviously. The main reason why the capture and turbulences in Poland could occur is probably because we never put in place a proper media order that was safeguarded by all the guarantees which come and result from the Council of Europe or EU recommendations. So what we have faced, and what is common to Poland, but also to Hungary, it's first of all the capture of public media, which is basically the first thing that has been done in Poland after the changes back in 2015. But it also the capture and abuse of institutions that are governing media. I'm mostly thinking about regulatory bodies. And this is not only the Public Broadcasting Council, which has huge competences in imposing, for instance, fines on broadcasters. So this is still being abused because the composition of the current Public Broadcasting Council in Poland is still the one inherited from the previous government. So just last week, one of the independent channels and very critical to the previous government, TVN, has been imposed more than 200,000 euros fine for one of their programs. So this is a competence that is still being abused. Another one was using also the competition authorities in blocking some media mergers or enabling others, basing on pluralism and plurality rules. So Agora, one of the independent media owner, Gazeta Wyborcza, was not able to buy Radio Z, and in the meantime, the same regulatory body, basing on exactly the same rules, allowed the buyout of almost all of the regional papers by Polska Press, which is owned by Orlen, so a state-owned company. And basically most of the regional titles became in the hand of the state, which obviously distorted the media order also at the local and regional level. And similar mechanism has been used in Hungary, and I'm thinking here about the Foundation Kezma, which is basically the owner of most of the independent media. But besides of the plurality aspect and the market, what has been mostly abused is various institutions of criminal law, of civil law, in order to suppress speech. And I'm thinking here of criminal defamation, for instance, and we have a number of judgments of the European Court of Human Rights against Poland, which has not been implemented for many, many years. And this is a matter of every single government in Poland that is not willing to change this and decriminalize defamation in order to align with the European Court of Human Rights jurisprudence. But it's also abusing civil defamation, which with high compensations against journalists, but also activists. So using the strategic lawsuits against public participation mechanism, SLAPs, against critical voices. And here we had a very good response and well welcomed in most of countries with turbulences from the European Union. And I'm thinking here about the European Media Freedom Act, which tries to respond to both pluralism questions internally and externally. And also the anti-SLAPP directive that has been adopted recently. And basically coming to the charter that we are discussing today, in the principle 5 relating to freedom of expression, we have perfectly this first component described, which is the plurality. And even going beyond what is in the European Media Freedom Act in the explanation, so giving actually a definition of what is external and internal pluralism. The external being the plurality of actors operating on the media actors, and the internal one being the operation and independence within one media, which is mostly the independence of journalists. And the ability to speak freely, sometimes even against the media owner, especially if the media owner is the state. What we do not have in the elaboration and the description of the Principle 5 is everything which concerns the well-being, let's say, of the functioning of journalists. And here I'm thinking about everything which relates to SLAPs and the institutions that are put in place by the state or that are abused by the state to suppress the voices. So this is obviously the defamation principles, but it's also blasphemy rules that are being used. But for instance, also the new law adopted in Hungary in December on the protection of sovereignty, which may affect the operation of NGOs and media. So I just have the impression this aspect is missing, and that has been a long-standing problem within the last years in Poland. It has been a problem since many years, but we just saw how the number of those kind of proceedings can plummet whenever they are in hand, and those institutions are in hand in non-democratic hands. And we are now in Poland facing a window of opportunity. And here, referring to Daniel Pesco, I think our change was possible thanks to the extremely high turnout and the huge mobilization. So something we finally can, as Polish people, we can be proud of. However, we see how viable the situation is. And looking at Slovakia and the fact that Fico government returned just after 4 years of break means that we don't have much time to actually put in place a number of changes in the media order functioning, being first of all recapturing the public media meaning defending the media from political influence, deleting all the institutions that refer to SLAPs. And here the EU directive actually comes timely and could be used as a basis of those changes. And similarly, the European Media Freedom Act, which we can actually rely on in order to put in place a number of changes concerning the independence of journalism, the plurality of actors. And also on a very last mark, whenever we are adopting a legal instrument, being at the European level of the Council of Europe level, I think we always have to keep in mind that those instruments might be in the hands of governments which do not have the same democratic intentions as we usually would like to think of. And even the European Media Freedom Act, with all the good sides it has, it also introduced the European Board for Media Services, which allowed all regulatory bodies from all member states to sit in. And imagine having the representative of Hungary and giving a lot of, or from Poland until recently, and giving all the competences to block some of the decisions, or at least to give opinions of major merger, media merger decisions in the European Union. So each time planning those institutions, please think, we need to think about how they could potentially be used by those kind of governments. Thank you.
Thank you very much, Dominika, for these very astute points, and also at the same time a kind of overview of some central aspect of Principle 5. I last but not least, I want now to give the floor to Robert Spano. As everyone knows, Robert Spano is the former president of the European Court of Human Rights, the youngest judge ever to be elected to the presidency in the court's 60-year of history. And after the end of his term, he entered as a partner of the London and Paris offices of a large law firm where he practices in the field of international dispute resolution and advises in regulatory matters. He does a lot of things linked to transnational litigation, ESG, international arbitration, but also artificial intelligence, technology, regulatory means, and further points. And needless to say that he's a leading expert, bringing unparalleled experience from senior roles in the judiciary, private practice, and academia as well. And so he will speak and bring us some reflections on protection against disinformation. That's Principle 6 of the ELI Charter. Robert, you have the floor.
Thank you very much, Pascal. It's been very interesting to listen to the colleagues, and thank you, Takis Tridimas, for your wonderful report and your colleagues, which I found very illuminating. All the charter that has been drafted is of course a consolidation and compilation of some already existing principles which flow both from treaty law, constitutional law, and case law, but there are also novelties in the charter which I find very interesting. I'm going to do this a bit differently from the others. I'm going to be a bit more, let's say, less technical and more realistic after 9 years on the European Court of Human Rights. I think we need to realize in the process of discussing at this level texts, charters, treaties, and conventions, we have to ask ourselves, what is the reason for the backlash against democracy, rule of law, and fundamental rights? What is the mischief that we are trying to react to? And I'm gonna bring 4 reflections, 4 points to that, and then another 4 points which are potential responses. The first is that the principles of liberal democracy, which we all know and cherish, are by now vast majority of our populations viewed as being controlled by vested interests. That's the problem. So in other words, legal texts such as fair and equitable electoral processing, a electoral system which is proportionate, which has effective supervision, are potentially legal tests which do not meet the requirements of the backlash. Point number two, and this is a huge issue. Recently, the EU's annual report 2023 on human rights and democracy made the point that human rights and liberal democracy are viewed as a substance of the Western liberal instrument of neocolonial domination. This narrative I saw in the court more and more. The idea that we are simply imposing a value system. There's a reference to Article 2 of the treaties. But is democracy about embedding a particular value system, or is it more the ability to openly debate differences of values? And those are two very different starting points. Point number three, the argument, the challenge is that democracy is a vehicle to impose, as I mentioned, a particular type of worldview. And that narrative is one which we will not be able to change with the consolidation of legal texts. It requires a mentality shift. And finally, the fourth point, liberal democracy and its challenges today are intimately related to substantive inequalities in our society. It is the merging of the challenge to the liberal democratic narrative with market capitalism as the dominant regulatory enforcement in the Western Hemisphere. So when we talk about these issues, let's not forget that we are dealing with a fundamentally far more difficult challenge than can be dealt with or remedied by legal texts. It has to be a change from the ground up. It has to start in primary school. It has to start with young children understanding what these principles are all about. So I would say, and this is my learning after all of my years on the court, you can deliver the most beautifully reasoned judgments, but unless they are met with an understanding and acceptance, they're not going to do very much. So what do we need to do? I don't have the magic bullet, but I would mention 4 points. First is, how do we induce the democratic process to be truly inclusive and public interest grounded? I'm very happy, Professor Tridimas, with the third paragraph of Principle 2, because that has been completely lost to many of our contemporary parliamentarians. Parliamentarians, a modern parliamentarian in a representative democracy has become a fighter on a team. He or she are no longer thinking about, or to a limited extent, are focusing on what can be collective interests. They're focusing on narrow vested interests of the underlying supportive system of their parties. So the principle that the mandate is an agent, as a trustee and not an agency, is extremely important. But that needs to be met with even stronger actions on that. Second, how do we harness the benefits of the online revolution? The problem currently is that the narrative about the online environment, intermediaries, is all about managing risk and harms. That's what it's about. Regulations are focused on limiting their reach, their influence, instead of taking a positive approach, because the solution, or one of the solutions for the democracy of the future, is one which has to be based on using the online environment. It's not going away. It is a game changer. It is now creating the most difficult challenge to the modern population system in the world that we have seen in our lifetimes. And if we only focus on the harms and risks it imposes, but instead of being innovative on how we can use them to better tackle the problems we're facing, then that is not going to be very good for us. The final point is, I think one of the most important additions in the Charter is Principle 28. We are not talking about that today, but that deals with the horizontal effect of human rights. That is the embedding of the obligations of private actors who have become super states or states within states that have a big focus. And I know from my own practice as an international lawyer working with many of these multinationals that they want to be a part of that process. They do not want to be viewed as the enemies. And unfortunately, politicians are rather using multinationals as big bad monsters rather than as collaborators in changing the system we're dealing with. So these are my reflections on, and they're very general, but I think we should not overestimate, although with all good intentions, the compilation and embeddedness of treaty text and charters is, of course, a very good thing. 3 technical points at the end. There are some gaps in the charter that I'd like to mention. The first is what Dominika just mentioned, and that is media pluralism. The issues related to the media are core. We have a recent landmark judgment of the European Court of Human Rights in the case of NIT SRL versus Moldova from 5 April 2022, which is not referenced in the charter. That is the main constituent judgment on media pluralism in Europe at the moment, and focuses very much on examining how internal and external pluralism must be viewed as a whole within the rubric of freedom of expression. Number 2, oversight of electoral processes. In a case called Muge Mangango versus Belgium of July 2020, that is another landmark judgment of the European Court of Human Rights, which actually takes the step in making it clear that there has to be external oversight, not only internal oversight by parliaments themselves, like in some constitutional regime. This judgment is not mentioned in the paper, and I think it would be useful to flesh that out as well. A final point of interest, as I'm practicing amongst others in the United Kingdom. The 5th paragraph of Principle 2, which talks about that sufficient guarantees must be provided for the protection of minorities. This is explained in the commentary as suppression of the fundamental rights of minorities shall not be permitted. It will be interesting to see how the authors of this charter will present this to the United Kingdom government, which will mean that they will have to change their constitutional system. Thank you very much.
Thank you very much for these points. I think it's also important indeed to have a larger perspective and ask on what are the systemic aspects linked to liberal democracy, and especially when dealing with a document like this ELI Charter that is a soft law, of course, and therefore should participate to the whole discussion and process on how to bring the, let's say, fundamental hard law issues into more reliable and effective means, of course, through the European Court of Human Rights, but also through other means. So thank you very much, Robert, for this excellent presentation. We have now about 40 minutes for a Q&A session. I do not see yet any questions posed to the panelists, but I thought I would begin with the first question, also a kind of general question to Takis Tridimas, because, of course, a number of points were raised. And as one of the 2 co-reporters, you might want to answer to these points, maybe to all or to some of them. There's the choice is yours. To what extent what has been said creates some, reactions, and also you want maybe to anticipate some further questions. So you have the floor, Takis.
Thank you very much, and huge thanks and gratitude to all commentators. This has been really extremely enlightening, extremely enriching. I'll pick up on a couple of points, and I'm doing this in a random way. I think in response to what Robert Spano said, I mean, I entirely agree. It is this charter is not panacea. We don't intend to remedy all evils. And I entirely agree with your point that it is a matter of that democracy is culture and it is a matter of education. I think we are doing our bit. That's how I see it. I think embedding these principles in institutional structures and processes makes a difference. And to the extent that the charter contributes to that, I think that would be a very good thing. The objectives are very modest. I didn't want to give any other impression. More specifically on points raised, and as I said, they're all extremely enriching, extremely illuminating. One of the issues that was raised, I think, by Daniel, I think, was that we don't refer to direct voting, direct suffrage. That's a good point. It is not stated in the principle, but of course the Venice Commission principles are recited in the commentary. So there is certainly reference to direct there. You're right that that it has not received the attention that the other elements of elections have received. It was felt that this was perhaps less of a problem. Maybe we're taking too much for granted, but yeah, it is a case of paying relatively less attention to it, without by any means suggesting that it is not a component of fair elections. An issue that Dominica raised, it's very interesting, about freedom of media. We don't talk about the weaponization of criminal law and how it can be used against the journalists. Yes, although I think that is a wider issue. It isn't really, it is maybe we assume too much. You're right, but I view this as a wider issue, not one the undoing of democracy requires a systematic effort. It is not. It requires the use of different instruments in combination with each other. Just as fundamental rights are a system, so is the undoing of fundamental rights. And I think it becomes clear by looking at all the principles of the Charter that the weaponization of the law for ulterior purposes is certainly against the principles laid down thereby. But it's an interesting point, and thank you for raising it. Final point, again, referring to Robert's reactions. Thank you for the references to the judgments of the Strasbourg court, and yes, I am certainly aware of them. Inevitably, I mean, when such a document is drafted, it is the result of a collective effort. Some contributors thought that we over-rely at the case law of the European Court of Human Rights. Others said that we don't refer to key judgments by the European Court of Justice. So there is inevitably the choice of cases is the result of collective exercise. So the absence of reference does not in any way intend to devalue the importance of these principles. And I appreciate the comment, but it isn't by any means an effort to sidestep them. It is a matter of compromising all contributions. So that's all. I don't think at this stage I need to say anymore. Thank you.
Thank you very much, Takis, for these short answers that enabled us indeed to go maybe further. Maybe waiting for further questions, I might give the floor to Daniel Popescu if you want to answer or react or ask a question.
Unless there are direct questions, I would like to make a few comments to the very intellectually challenging presentation done by Robert Spano. I think his presentation, of course, was brilliant, and indeed he identifies 4 different, let's say, causes of the democratic backsliding. Now, my question is: are they independent, or do they derive one from the other? If you wish to make it simple, we use the terms liberal democracy as a shortcut for a consensus between 2 concepts which at their extreme are opposing concepts. Extreme liberalism doesn't need democracy. It needs only reinforcement of contracts, while extreme democracy will basically end by violating human rights and by ensuring the decision minority, that majority becomes authoritarian. So my belief is that indeed in the last, let's say, 40, 50 years, there has been a shift of this compromise, of this nice place of compromise between 2 concepts towards liberalism, more liberalism, less democracy. And the causes are multiple. And indeed, Mr. Spano said the first thing is, no, let's start with the last one, that indeed we have the question of growing inequalities. And suffice to look at all the indicators of inequalities, and we'll see that since the 70s, inequality in our society has continuously increased. And one of the reasons is that indeed citizens have less of a voice, less impact, less influence on decisions taken on their behalf. And then we come to the first element, which was presented by Mr. Spano. And indeed, the feeling of a certain part of the population that decisions taken by political powers which are supposed to be inspired by common good, are in fact, controlled by vested interests, which may be to a certain extent true, because we are into a, let's say, liberalization mood in which indeed capitals flow freely, and most countries are trying to attract them, by remunerating them more, so they remunerate, work less. So there is this trend of going towards more liberalism, and then this is punishing for a large category of population. And hence we have all this disenchantment, all this disappointment, all this disaffection of citizens, and we have trust rate of 10% in the parliament, 30% in the president, and 60% in the military, which is of course absurd in a democracy. Then indeed, Mr. Spano brings 2 elements which are indeed very interesting, and I think linked together about something which is the title of my job, if you wish, promoting democracy. And this is the question about democracy, liberal democracy, being seen as either instruments of a sort of Western colonialism, and indeed that we are trying to impose a certain vision of the world. And I think this is very accurate, and I wonder whether indeed maybe our decision makers have not trying to compensate the lack of trust, diminishing trust internally, domestically, by being more persuasive, to not say aggressive, into promoting these values, which I think are fundamentally very important abroad, and lacking the domestic legitimacy, the others can see this as sort of a unfair, let's say, intrusion into their culture, way of life, and way of organizing societies. And I'll come back to the only remedy I can see is to inject more influence of citizens. That's why I was thinking about this, citizens' assemblies, panels, and juries, and how badly they're organized sometimes. And I think that many countries are now discussing to institutionalize this kind of organizations, like, let's say, like a 3rd chamber of the parliament. So to give some constitutional guarantees for this kind of for the moment, informal, more or less informal get-togethers of randomly selected citizens who spend time to educate themselves with a theme, and then to have a voice which is stronger than that of, let's say, the big businesses, big corporations, and indeed who count more in the international competition for more funds, more economic growth, more resources that countries wage against each other.
Thank you very much. Let me mute you. Yeah. Now you're muted. Yeah, perfect. Thank you very much for these points and reactions. Of course, I just wanted to stress that the ELI Charter on Fundamental Constitutional Principles are for European principles. So at least they do not intend to be applied to any other communities, countries, but I understand also Robert Spano saying these fundamental principles need to be more concretized in a way so that they are shared value and not only common values for the people living in Europe in more general terms. And if I understand you correctly, Daniel Popescu, you say, okay, we need to have education to democracy, like what Robert Spano said, but at the same time have institutional means. Well, I'm sitting in Switzerland, where of course we have in a way an education through an institutional mean, in the sense that through the referendum, people have to get more and more used to understanding what is going on, and are also trained partly at school in order to have their say. But it is true, to go back to one point that was referred before, the level of participation is not very high. And we just had a referendum and also constitutional initiatives on which we voted last week, and the level was at a bit more than 50%, but that was considered as very high. Usually it's more around 35 to 40%. So you could say, okay, people are not interested, but maybe they just consider that the majority might also be in line with what they think, reading the press and so on. So these are institutional, but also, of course, other means that should be applied. I fully agree with what Robert Spano just mentioned before. I was, since we still wait for maybe a further question, I wanted to ask Ralf Kessner whether, because you mentioned the potential of revisiting fundamental rights on EU level and trying, or maybe not fundamental rights, but common principles, fundamental principles, and having maybe a charter or a new charter. And the question I wanted to ask is, to what extent the principles that you read in the ELI charter would be of any impact, or because of course it's soft law, it brings up what is already there in terms of also implementation, but also opens on new potential. Do you think it might have any impact? And if so, what should be done to enhance the impact if one thinks that this is important?
Yes, thanks, Pascal. Very useful, the charter, from the perspective that it fleshes out all these very short principles that we find in the treaties that are the basis of the European Union, and so it's a really helpful reference to see the very broad background to all these principles. They are the premises that they are common to all member states in the Union. And so, but still, of course, every member state has its own traditions. Every member state also insists very much that his own national setup needs to be respected. And so they help to, the charter can help to kind of distill the essence, if you want, of these principles, the kind of minimum that has to be there in every member state. At the same time, they will all insist very much on their own national, historical, cultural forms of these principles. But that's where I see the main added value of this charter, and to sit down once and reflect. It's an academic work, of course, and here in the political debates and negotiations, this is often relegated to the kind of the second rank. The actual problem needs to be solved in negotiations, but to everybody involved in the actual negotiations, it's very useful background information that helps them to find the common ground that you need to define and establish.
Thank you very much. I understand when you say academic work, you mean not a political document, because of course,
Absolutely.
the European Law Institute has also judges, attorneys, and practitioners, and not only academics.
Absolutely, no, but
Okay,
from an objective kind of perspective,
yeah,
without all the political noise that we here see in the council.
Yeah, indeed. I wanted to briefly give the floor to Dominica and then back to Robert and Takis, maybe for final words or comments they want to do, because I see that the clock is ticking. So maybe Dominica, you could react to something that was said before.
Yes, well, basically, I think I have just one reflection and comment, taking into account the situation we are in, but I hope other countries which were facing turbulences would be at some stage, is that we are bound by time. And we know that reforms and restoring some of the democratic institutions should be done promptly. Here I am just thinking to what extent the already existing institutions, as we know, like the citizens panels, more citizens participation, is something which is feasible, and where time constraint will, although it's the preferred model of restoring some of the institutions, having a broader citizens participation and a say in various of the processes. And this is definitely something we would like to see. But the question is where we are facing a time restraint, because we don't know how the current coalition, at least in Poland, how much stable it is, means is there another way and of doing things and restoring the democratic institutions fast and promptly? So this is the only question, listening to you, and I understand we need to rely on public participation and refer to the institutions we know, and this is also enshrined in the LI Charter. However, we would probably have the similar situations of restoring a rule of law, of restoring the democratic institution, where time we will be bound by time, and we also have to have some of a remedy, I would say, for this time constraint that should be in place.
Thank you very much. Robert Spano, you have the floor to react to whatever.
Thank you very much, and thank you for again hosting this. Point number one is to be absolutely clear. I think the Charter, in many respects, is a remarkable document. It has quite a number of novel principles, which I think should definitely be developed even further in a robust debate. And I mentioned some of them. The second point that I would make is, yes, the geographical context we are talking about is Europe, but let's not forget Europe is a big continent. It has, it depends how you count, probably about 49 to 50 states. If we include Vatican City, I'm not always sure where to put Vatican City in that context, but yes. So this is a very big continent, and it has outsized influence on the way in which other parts of the world also develop. For example, like the African continent, with our very close historical ties. So the way in which our future is going to look like in Europe is very much going to be conducive to how the concept of liberal democracy will unfold. And the problem we're facing now is that Europe has become again, a continent heavily divided on these issues. We are seeing more and more states use, and this is interesting, use the specter of democracy, and in particular liberal democracy, as a potent tool to get voters based on the assumption that democratic values are not serving their interests to coalesce behind them. And Dominica comes from one of those states which recently went through that process, and we know other states. That is where the battleground has to be fought. And that is where I think, going back to a simple question, because I go around primary schools in Europe to talk about democracy. That's what I started to do after I left the court. Does anyone on this call, and I ask Ralph in particular as a representative of the European Union, does anyone on this call know when in school curricula in the European Union the words democracy and human rights are first taught to children? I'm not sure you do. And the problem is, a child will not be told what democracy means, what human rights are, before they reach late adolescence. That is the fundamental problem. This is not just a rhetorical tool for high power intellectual elites like us that love to talk about charter rights and convention rights. And this is something that needs to be brought down to the average person. They need to be asked a very simple question. Do you know how your life will look like if there is no democracy? Can you tell me what human rights you are willing to be without? And I'll name a few, and you tell me if you can live without them. That is the kind of debate I think we need to have for the future.
Thank you very much. And thank you very much also for this very important work, I think, indeed, which is education to human rights, education to democracy. I hand over for 2 words to Takis if he wants to add something, and then I will just say a few final words. Takis, you have the floor.
Thank you very much. Just 2 points. The right to democratic education, and indeed the obligation of the state to provide for that, is actually provided in the Charter. We had it's part of social rights. So under the chapter of human rights, we refer to it. There's a good chunk in the commentary, and we had quite a long debate as to whether we should elevate it to a self-standing principle. And it was felt on balance that it certainly needs to be mentioned, but perhaps we should not elevate it to a principle on its own. That doesn't mean that it is not important. It has to do with, in a document of this character, with also the technical allocation of principles. So point taken, and I could not agree more. Second point, more general, the difficulty with drafting a document of this character is that one needs to facilitate consensus. So it needs to operate at a level of generality that does not target specific violations or specific countries. I think that's important. On the other hand, it has to be meaningful. And it has to be objective. So it is not, a lot of the things that we discussed here are extremely valuable and in many ways more important than the document. But this is not a political manifesto. It is a document which seeks to add to the, if you wish, the soft law instruments that specify standards of good governance and stress the importance of rights. So this interplay between the generality of the document, which is needed to facilitate consensus on the one hand, and secondly, specific references to cases. Sometimes we refer to specific factuals to illustrate the principles. Needs, I think, to be done at a level that guarantees a political neutrality, if you wish, to add to its resonance and its legitimacy. Thank you very much. I think this is an extremely enlightening debate, and I'm really very, very grateful. Thank you.
Thank you very much, Takis, for these words. I just wanted to say that the ELI charter may be also a tool not just to do managing risks and harms, but really try to bring the community together to think about these fundamental issues. And we have seen today, thanks to you fantastic panelists, with your also thought-provoking ideas, you managed to bring us maybe closer to understanding what all this is about. And I think if we manage to put that in context, that is certainly a wonderful